State of Ohio versus Christopher Hutchinson, 22 CR 256. You're Christopher Hutchinson, appearing there from the jail.
Yes, sir, Your Honor.
Right, Mr. Hutchinson's attorney, William Armentrout. This hearing is being conducted by Zoom. Mr. Armentrout's appearing from his office. Appearing on behalf of the state from the prosecutor's office is Adam King, assistant prosecutor. The defendant is charged in a one-count indictment with receiving stolen property, and this hearing is set for a plea. Now, Mr. Armentrout, you and your client both agreed to the matter being conducted by Zoom remotely rather than in-person appearance in the courtroom.
Yes, Your Honor.
And you're all right with that, Mr. Hutchinson?
Yes, sir, Your Honor. May I have a blackout with my attorney, Your Honor, or whatever it's called?
Yeah, breakout room, yeah.
I'm sorry.
Okay, not a problem. I was just going to tell you can do that, so I'll go ahead and do that now. Okay, 23 CR 122, State of Ohio versus Michelle Lynn Sines. And you're Michelle Lynn Sines, appearing there on the screen is marked Milt.
Yes, Your Honor.
All right. This is a hearing being conducted by Zoom. Ms. Sines' attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. Mr. Kirk, you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor.
And that's all right with you, Ms. Sines?
Yes, Your Honor.
All right, Ms. Sines is charged with, looks like counts 1 and 2, and 5 and 6, 2 counts of aggravated trafficking of methamphetamine, 2 counts of aggravated possession of methamphetamine. I have a proposed plea agreement here, Ms. Sines, which indicates you're going to plead guilty to count 1 and count 5 of the indictment. I'm going to hold that up to the screen in front of the computer to see if you recognize that. You recognize that?
Yes, Your Honor.
All right. And on page 3, there are signature lines. And about a third of the way down, there's a sentence that reads, I enter this plea voluntarily. And then a little below looks appear to be the signature, Michelle Sines. Is that your signature?
Yes, sir.
Hey, Ben, we're having the same problem we had when they supposedly fixed it last week. So. All right. When did you sign this agreement, Ms. Sines?
Yesterday, Your Honor.
All right, and had you been discussing this with your attorney before you signed it?
Yes, sir.
And he explained everything to you in the agreement?
Yes, sir.
And did you understand that when you signed this, it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
All right, did you enter into this agreement to plead guilty voluntarily?
Yes, Your Honor.
And is that still what you want to do today, voluntarily?
Yes, Your Honor.
Right now, the agreement states you're going to plead guilty to count 1 and count 5. Both are aggravated trafficking of methamphetamine under 2925.03A1. Count 1 is a third-degree felony, which carries a possible prison term between 9 and 36 months in certain increments provided by law, and a fine of $10,000, and aggravated trafficking and a mandatory fine of $5,000. And count 5 carries a possible penalty of 6 to 18 months and a fine of $5,000. Both have a possible driving suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
And as to count 1, there's a presumption that a prison term should be imposed, but it's not mandatory. Do you understand that?
Yes, sir.
If you are sentenced, or if you are convicted of both these offenses and plead guilt and are sentenced to prison on both, sentences could be ordered to be served consecutively, meaning one after another. So that means that the prison term could be as much as 54 months, and the minimum would be 9 months, since that's a minimum on count 1. And the fine could be $15,000. Do you understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
Yes, sir.
I'm sorry, you say yes or no?
Yeah, I was indicted while I was in here. They haven't been disposed of yet.
Where's that?
It's Athens County.
All right. And,
It's a receiving charge.
all right, so if you are convicted in that county as well, and if you should be sentenced to prison in both counties, those sentences could be ordered to be served consecutively one another. You understand that?
Yes, sir.
All right. Now, are you currently on probation, community control, post-release control, or parole for a felony in any jurisdiction?
No, sir.
All right. Now, under the law, if you are convicted of these offenses and sentenced to prison, upon completion of that prison term, it is possible that the Adult Parole Authority may put you under post-release control for a period of up to 2 years, which means you'd be supervised by a parole officer in the terms they state. If during that period of time they determine that you had violated the conditions, they have the authority to return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if your violation is a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time might be left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
All right. Now, under the law, I'm not required to sentence you to prison. As I said, there's a presumption on count 1, but it's not mandatory. So that means instead of going to prison, you could be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. If during that period of time the probation department felt that you were not compliant, they would file a written notice of that. There would be a hearing. You'd get a copy of it, of course. You'd be entitled to have an attorney. If the outcome of the hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison and for a period of 9 to 54 months and fine you $15,000. You understand that?
Yes, sir.
All right, now count 1 alleges on or about November 3, 2022 in Highland County, Jason McCoy and you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, to less than 5 times bulk amount, in violation of Section 2925.03A1. Count 5 alleges that on or about November 8, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance. So both of those are the offense of aggravated trafficking of methamphetamine, the penalties I've just described. Do you understand what it is you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged that you did it?
I do, Your Honor.
And have you discussed the nature of these charges, the evidence in the case, possible legal issues in the case, and possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
I have, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are several sentences printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1 and count 5. State will dismiss remaining counts. State defense will argue sentencing. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay bond money to the task force as follows: $80 joint and several with Jason A. McCoy, $40 alone. Is that your understanding of the plea agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is reserved to the judge, not the parties. And so even though there's an agreement as to what the sentence should be, if you plead guilty, once I've heard all the information that's presented, I'm not required to follow that recommendation. I couldn't sentence you to anything between 9 and 54 months and fine you as much as $15,000 and suspend your license for 6 months to 5 years. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
I do not.
Now, you have certain rights you must understand before I can accept your plea. First is your right to counsel, which I appointed Mr. Kirk to represent you, not simply to work the case out, but to provide any defense that may be available to you under the law that you like him to provide. So if you decide you do not want to do this, that you would rather defend against these charges, he will continue to represent you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to a jury trial in this case, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The judge will instruct them on the law. Then that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up your right to have a jury trial. In that case, you would have a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the state is done presenting the evidence, your attorney has the right to ask questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to compel witnesses to come into court to testify on your behalf, the same as the state. What that means is that if you have witnesses you're not certain are going to come in to testify on your behalf voluntarily, at your request, the court issues a court order that's called a subpoena, which forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's up to you. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
And under the Constitution, you have a right to, or you are presumed innocent until proven guilty of this offense by the state of Ohio on every essential element of both offenses. So the burden of proof isn't on you to try to prove you're not guilty of these two charges simply because you've been accused. In fact, under the law, you're not required to put on any defense at trial at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each of these offenses by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea as to these two charges. The guilty plea would admit the allegations in both counts 1 and 5, admit that they're a crime, that you committed those crimes, and that plea would waive or give up all of the rights I've described for you today except the right to have an attorney, which you always have no matter what your plea. With that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and cross-examine them through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence or under other certain circumstances, there could be an appeal filed. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charges or the possible penalties for either charge?
I do not.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
I do not.
You understand it?
Yes, sir.
And you understand that the recommendation on sentencing is not binding on the court?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
Now, I didn't tell you this at the beginning of the hearing, but if you need to talk to Mr. Kirk, I can put you and him into a breakout room where just the two of you would talk on the screen. No one else would be able to see you or hear you. Do you need to do that for anything?
No, sir. I'm fine with
All right.
proceeding.
And do you have any questions then about anything I've explained here this afternoon?
I do not.
And is it your decision to voluntarily withdraw your not guilty plea, plead guilty to counts 1 and 5 pursuant to the terms of the plea agreement that we just gone over?
Yes, Your Honor.
Then as to count 1, which alleges that on or about November 3, 2022 in Highland County, Ohio, Jason A. McCoy and you did knowingly sell or offer to sell methamphetamine to Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount in violation of Section 2925.03A1, the charge of aggravated trafficking of methamphetamine, a third-degree felony carrying a possible prison term between 9 and 36 months in increments provided by law, a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
As to count 5, which alleges that on or about November 8, 2022 in Highland County, Ohio, you did knowingly sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1, also a charge of aggravated trafficking of methamphetamine, being a fourth-degree felony, carrying a possible prison term between 6 and 18 months, fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds that on this day in open court, defendant made a no intelligent voluntary waiver of her rights pursuant to Criminal Rule 11. The plea is accepted, ordered filed. Defendant finds defendant guilty of each of the 2 offenses to which he's entered this plea. Counts 2 to 4 and 6 are dismissed. The court will refer this matter for a pre-sentence investigation under the same bond. They'll include an assessment for substance use disorder and or mental health issues. Sentencing will be November the 8th at 9 a.m. Ms. Sturgill, will Mr. Arjima reach out to her then there at the facility? Okay. All right, so they'll be getting in contact with you to prepare the report and do an interview with the sentencing hearing will be in person. So,
Okay.
all right. Anything further from counsel?
No, Your Honor.
All right. Thank you.
Thank you. Have a good day.
You too. All right, we're back on record on case number 22 CR 256, State of Ohio versus Christopher Hutchinson. Are we going to go ahead and proceed, Mr. Armentrout?
Yes, Your Honor.
All right. All right, now, Mr. Hutchinson, you've already done it, so you're familiar, but if you need to talk with Mr. Armentrout any further during this hearing, just let me know, and I can return you to a breakout room, okay?
Thank you, Judge.
All right. Now, Mr. Hutchinson, I've been handed a plea of guilty form, which indicates you're going to withdraw your not guilty plea and plead guilty to the charge in the indictment. I'm going to hold up the first page to the camera and ask you if you recognize your name and the case number and the plea of guilty form there.
Yes, sir, Your Honor.
All right, and on page 3, there's a sentence about a quarter of the way down the page. It reads, I enter this plea voluntarily. And right below that looks to me to be the signature, Chris Hutchinson. And I'll hold that up, and is that your signature there on the camera?
Yes, sir, Your Honor.
And when did you sign this document, Mr. Hutchinson?
Did you say when?
When, yes.
Yesterday, I'm not sure, Your Honor. It was yesterday, Your Honor.
Okay, all right. Now, when you signed it, before you signed it, I should say, did your attorney go over it with you and explain everything to you to your satisfaction?
Yes, sir.
And did you understand that by signing this, it's an agreement to plead guilty, which means there won't be a trial next week, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
No, sir, I did not.
And why is that?
Uh,
The case has been going on for a long time. We've had several pretrials. What's the problem?
yes, sir, I did.
I mean,
yes, sir.
is there a concern you have? I don't know. I mean, it's one charge. It's not a real complicated case.
There's just one thing there at the bottom of the, I'm sorry, Judge. It looks to me like it's maybe page 2.
Of the plea agreement?
Yes, sir, Your Honor.
Okay.
I don't know, it doesn't, may I have a break, time with my lawyer again?
Sure.
I'm sorry, Judge.
Not a problem. Case number 19 CV 287, Calvary SPV ILLC versus Lauren N. McElwee. You're Lauren N. McElwee? All right. And Ms. Barger, I don't have an entry of appearance. Did you enter an appearance in this case?
No, Your Honor,
Okay.
I'm covering for the attorney.
Well, there's no such thing as that. You need to, I'm going to let you get by with it this time. This is the last time. Anytime anybody calls a local attorney, say, cover for me, there's no such thing. You have to enter an appearance. You have to be counsel of record to appear in front of a court and make an argument. And if these people don't want to come down here to appear at hearings, then they ought not file cases. They should refer them to local attorneys who will. So make sure you point that out to them the next time. Because I know what it is. They throw you into the lion's den and you don't have any background, you can't answer any questions, you don't have any authority to negotiate, and it's a waste of everybody's time. Now, that being said, my understanding is the garnishment was to Scarlet Rose Photography for employee wage garnishment, and Ms. McElwee, you've indicated that you are self-employed, you're not an employee. Is that your business? Okay. All right, so you don't pay yourself a salary?
No.
All right. All right, well, so based on that, the court will have sustained the objection because it's not filed in a proper, I mean, there is no employee-employer relationship there. And so if they wish to garnish, I assume they'd have to garnish bank accounts or other assets that you might have. But it really, since it was returned, they should have withdrawn the garnishment because of the fact that there's no employer. So I will sustain that, and you can convey that to Mr. Levi's, or Levy, at office. All right, thank you. They'll probably file. All right, go ahead and put us back on record, Hutchinson. All right, so we're back on record with State versus Chris Hutchinson. All right, so, pardon me?
Judge, you're muted.
Oh. All right, thank you. Back on record, State versus Christopher Hutchinson. All right, are we, where are we staying now, Mr. Armitrout?
We're going forward, Your Honor.
All right, so you've fully feel now satisfied that you've had enough time to go over this with your attorney to do this?
Yes, sir, Judge, and my apology, Judge.
All right, not a problem. I don't want anybody to be concerned. I mean, I'm just trying to make the record clear so we
Yes,
know what's going on. It's not a problem at all.
Yes, sir. Yes, sir.
All right. Now, the law provides that, well, I'm sorry, go back to page 1. The agreement says you're going to plead guilty to the charge of receiving stolen property under 2913.51 of the revised code, 5th degree felony. Further states you understand the maximum prison term for that is 6 to 12 months, fine of $2,500. And I believe in your case you do have a PRC sanction that is what, less than a year?
Yes, sir.
Okay. And so under the law, if you were sentenced to prison, if you're convicted of this offense, the court could, in addition to a 12-month sentence, impose 1 year on you because the law says it's either 1 year or whatever time's left on the PRC, whichever's lower, and that has to be served consecutively. You understand that?
I do, Your Honor.
All right. And now, other than that situation, are you facing any felony charges anywhere else?
No, sir.
And are you on probation or community control or parole for any other, or PRC for any other offense in any other court? You're on PRC for this court, I believe, aren't you?
Yes, sir.
But I mean, you have any other cases besides that
No,
one?
sir. No,
Okay,
sir.
all right. Now, under the law, Mr. Hutchinson, if you were convicted of this offense and if you were sentenced to prison, it'd be possible that the Adult Parole Authority may choose to put you under post-release control for a period of up to 2 years under the terms they set. They don't have to, but they can. If they do, you'd be supervised by a parole officer on the terms they set, and if during that period of time they determined that you had failed to comply, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in that new case can impose, just like here, that judge could also sentence you for committing that offense while under post-release control in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that has to be served consecutively, sentenced in a new case. You understand that?
I do, sir.
Now, under the law, this is not a mandatory prison term offense. I'm authorized to sentence you to community control, which means probation. That's what most people know it to be. That means that you'll be supervised for a period of up to 5 years under the terms set by the court, by the probation department. And if during that period of time the probation department felt that you were not compliant, they would file a written notification that the court serve a copy on you. You would have a hearing. You would be entitled to be represented by counsel at that time. And if the outcome of that hearing was that you had failed to comply, then at that time you could be ordered to serve 6 to 12 months imprisonment and fined $2,500, and possibly the PRC if it was still there. Do you understand that?
I do, sir.
Okay. Now, the charge alleges, Mr. Hutchinson, that on or about October 13, 2022 in this county, you did receive, retain, or dispose of certain property being a 1987 Alley camper and other miscellaneous items, property of a Kim and Leonard Ruslow, and that you knew or had reasonable cause to believe that had been obtained through the commission of a theft offense, the value of the property being equal to or exceeding $1,000 but less than $7,500 in violation of section 2913.51 of the Ohio Revised Code. So that's the charge that's against you, and you understand what it is the state has said, when, where, and how they let you did it.
Yes, sir, I do understand.
And you understand the possible penalties.
I do, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you may try to raise at trial, and the possible outcomes of a trial with your attorney?
I have, sir.
And are you satisfied with his advice and competence in this matter?
I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs there at the jail?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there are a couple of lines printed in bold that read as follows. Defendant will enter plea of guilty to the indictment. State and defense jointly recommend community control and referral to drug court. Do you understand that to be the agreement?
Yes, sir, I do.
Has anyone promised you anything other than that to get you to plead guilty today?
No, sir.
And under the law, I'm not required to follow the recommendation of the parties because the judge is the one who decides the sentence. And so If you plead guilty, I could determine that that's not the correct sentence and sentence you to serve 6 to 12 months, which would be consecutive to your current term, but would be in the county jail under our new TCAP program rather than in prison. Do you understand that?
I do, Your Honor.
All right? Now, do you hold any license or certification from any state governmental agency that regulates any occupation, trade, or profession, Mr. Hutchinson?
No, sir, I do not.
Right. Right, you have certain constitutional rights, you must understand, before I can accept the plea of guilty from you. First, you have a right to have an attorney. Mr. Armentrout's been appointed to represent you in this matter. His appointment wasn't simply to try to work the case out, but to provide any defense in his representation of you that may be permitted under the law. So if you decide you do not want to do this, and you want to defend against the charge, he'll continue to represent you, including having a jury trial next Tuesday or Wednesday, whenever it's set, if that's what you want. Do you understand that?
I do, Your Honor.
Now, under the Constitution, you have a right to be tried by a jury of 12 people in this matter, and those people would be selected from a group of citizens that live in Highland County that are summoned for jury duty next week on your trial day. After 12 of those individuals are selected, the evidence will be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means give up in writing, your right to have a jury trial. In this case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir, I do.
All right, now under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. That means that the witnesses against you have to come into court and testify in public in front of you and your attorney and anyone else may be here. After the prosecutor's done asking questions of those witnesses, your attorney would have a right to ask questions, which is called cross-examination, the purpose of which is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir, I do.
Now, under the Constitution, Mr. Hutchinson, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those witnesses to come into court to testify if you wish them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir, I do.
Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's your decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one can even comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir, I do.
Now, under the Constitution, Mr. Hutchinson, you're presumed innocent of this offense until proven guilty by the state of Ohio on every essential element of that offense. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir, I do.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed a crime, and it exercised or invoked all the rights I've just described. If you change your plea today from not guilty to guilty, Mr. Hutchinson, that is the opposite of the not guilty plea. Not guilty plea, or the guilty plea admits the allegation in the indictment, admits that those allegations are a crime, that you committed those acts and crime. And that plea waives, gives up all of the rights that I've explained to you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of this court to compel or force witnesses to come into court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, and that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I do, Your Honor.
And Mr. Hutchinson, are you a U.S. citizen?
Yes, sir, I am.
Now, do you have any questions about the charge and the possible penalties?
No, sir, I do not.
You understand them?
I do.
Have any questions about the plea agreement?
No, sir,
You understand it?
I do.
You have any questions about the constitutional rights I've explained?
I do not have any questions.
You understand them?
I do.
Have any questions about the plea of guilty, what it means, what the consequences of that will be if you enter it here today?
I do understand.
All right. Is there anything further you'd like to speak with Mr. Armentrout about before we go any further?
No, sir.
You have anything that I've explained here today?
No, sir, I do not.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge?
No, sir, it's not.
You do not want to plead guilty?
I do not.
All right, so you want to have a trial next week?
Yes, sir, I do.
All right, then we'll see you then. Thank you.
Thank you, Your Honor.
That's all right, we'll go ahead and go on record. It's case number 23CV016, Stephen Ritt versus Vida Viola, as it will be corrected, Nelson, executor of the estate of Leroy Smith and Wanda Ritt. This is a pretrial. Mr. Judkins, John Judkins, Greenfield is appearing on behalf of plaintiff. Viola Nelson did file a written answer on March the 3rd, but is not present. This is a pretrial. Court will note that Mr. Judkins did file a motion for summary judgment and judgment on the pleadings, and the court set those for a non-oral hearing and entered a scheduling order, which provides that her brief is actually due by Friday, and then reply brief will be due the following week. But if she does not file a reply brief, then I'll go ahead and rule on the judgment then next week, Mr. Judkins. I do have one question. The prayer wishes for the title to be put in your client's name alone. It does say that he and Miss Wanda Ritt bought it together. Were they married and subsequently divorced?
They were married and subsequently divorced.
And was it awarded to him in the divorce settlement?
The divorce settlement awards it to him.
Okay. If you would, file a copy of that as an exhibit in support of your motion so that I have that in the entry. And if you would, go ahead and prepare a judgment entry, and I'll go ahead and sign it because I don't assume she's going to be able to file anything that's different. Just include that statement in there that it was, whatever the case number is. Well, attach it to the entry. That way it'll show that it's proper to award it to him then. So, and it seems pretty clear on her admission that the statute of limitations bars collection of the debt. So, although I haven't researched it, it used to be 15 years on a written contract. Is this an oral? Yeah, I know they did change it, but I did not look at the bill. Did they, does that apply to debts that were accumulated prior to that, or only to debt since then?
So the way I read it is, so it was.
You're covered either way. I
Say that
think.
again?
I think you're covered either way.
Yeah, it's
Yeah.
like 29 years or something.
Yeah, yeah.
But the way I read it was, it was the second time because they amended the statute of limitations 2 times within 2 years, I think.
Mm-hmm.
And on that second one, they made it to be, nope, it's just 8 years and 2 back.
Okay.
But honestly, I mean, that's how I read it.
Yeah. Well, like I said, it doesn't matter whether it's 8. I would put in there that it's over 29 years, and you cite the statute and say, therefore, the claim it's barred. Yeah. Statute of limitations has expired. That would be my ruling. All right. Well, that's it then. Thank you.
Thank you, Your Honor.
Case number 23CV0030, Mediterranean Shipping Company, Inc. versus Dixie Express LLC. This is a hearing on a motion, damages for a default judgment motion filed on behalf of the plaintiff. You're Blake Thomas?
Yes, sir.
All right. Mr. Blake Thomas, attorney on behalf of the plaintiff. The defendant, Dixie Express LLC, has not filed an answer, although they were served according to the file by ordinary mail. And then I believe also there was personal service on the statutory agent on June the 5th. So the plaintiff is seeking $45,450 on the count, which was attached to the complaint. So I do have an entry for that amount. So is there anything else you'd like to present then, Mr. Thomas?
No, Your Honor.
Okay. In the future, once your entries are double-spaced, the local rules, everything's double-spaced on pleadings of any sort, entries and so forth. Exhibits and those kind of things don't have to be, but those do. All right. Thank you.